This is a prophecy and a warning message to the Nigerian government. Whether the Nigerian government like it or not, Nnamdi Kanu, the leader of indigenous people of Biafra, IPOB, must be released. The Lord have decreed it. I have given this prophecy before.
Hello my fellow Biafrans, I'm back again. But before I say anything concerning this particular video, I beg, what I need from you is for you to share this particular video, because it is very important for you to share it, because this man of God that you people are seeing on my screen like this has a very strong and important message that he has to tell Biafrans. So stay tuned and hear from him, and do not forget to share so that other Biafrans can also benefit from this particular video, because he says something concerning what is about to happen to Nigeria and what is about to happen to Nnamdi Kanu. So stay tuned and hear from him, and do not forget to share. And in case you haven't subscribed to this channel, what are you waiting for? Subscribe so that any day, anytime updates like this drop, I can be able to bring it here. So share this video and remember, bless. One love.
This is a prophecy and a warning message to the Nigerian government. Whether the Nigerian government like it or not, Nnamdi Kanu, the leader of indigenous people of Biafra, IPOB, must be released. The Lord have decreed it. I have given this prophecy before. The Lord is saying, I have no charge against this young man. And if the Lord have no charge professed against him, the charge of woman is in vain, is futile. And this is a message again. The Spirit of the Lord is saying that the Nigerian government should take it easy with the protesters that are preparing to protest for the release of Nnamdi Kanu on the 20th of October. They should rather protect the protesters. Any attempt to stop them, any attempt to harm them into prison, to detain them, to arrest them, is going to turn out chaos. I have given this prophecy before. So Nigerian government should be careful on how to handle these protesters in coming days. They rather protect them, they rather secure them. Let them do their peaceful protest. But any attempt to intimidate them, to harass them, to stop them, to arrest them, is turning into something that Nigerian government could not handle. Thus says the Lord.
No. We remain as consultants to him and as his brothers and braves in council.
Based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empower the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the procedures today.
The procedure today?
The procedures today.
Okay.
What next?
I will yield to one of my colleagues to discuss that.
It's good for us to put the record straight. Mazen Nnamdi Kanu is not saying that he will not enter defense. Mazen Nnamdi Kanu said, under what law are you charging me? Going by the Constitution, there is no charge against him. That tell me the law, that the court should tell him the law upon which he's been tried. Now, my Lord is on his own saying that whatever thing that you have to say should be ruled at the final written address, and it should be upon a conviction to know whether you are supposed to be convicted or not. And Mazen Nnamdi Kanu said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my Lord said, we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Mazen Nnamdi Kanu filed, Mazen Nnamdi Kanu said, Federal High Court has given a judgment in respect of that and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave a ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the jurisdiction of the court where these issues are being raised, and Mazen Nnamdi Kanu made reference of the motion in the court file. And under the Evidence Act, Mazen Nnamdi Kanu is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in your file. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. That court is on its own supposed to take so to raise this issue. Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Mazen Nnamdi Kanu filed the motion, and I think that motion, Mazen Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So, and we're into defense. So my Lord, Mazen Kanu maintain his position on that. So my Lord said that he has joined to tomorrow for him to enter defense. Just like we said, we are no longer into the matter, but we are he's still consulting us. I am saying so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Mazen Nnamdi Kanu refused to enter defense. No, there is no such issue. Mazen Nnamdi Kanu said, address me on this issue. Okay. That is the position.
The honorable member here will.
My name is Right Honorable Obi Akocha. I represent the great people of Iguano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazen Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazen Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
My colleague here would like to brag.
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, as I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist. And particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. The honorable, did you make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law that is not existing. Thank you.
Thank you very much.
As you can see the way I dressed, Nnamdi Kanu, for the purpose of this trial, is representing himself in this matter. So, and on this particular issue, we are now acting as his consultants. I'm not the only one. He has many consultants, both foreign and local, whom he consults on this particular issue, not representing him here. Now, if you recall, Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So, in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So ordinarily, the court is expected to show me to raise this issue and ask the parties to address him on this issue, whether the law does exist. So now Nnamdi Kanu has raised the issue and said that I cannot enter defense because in a criminal jurisprudence we have a procedure. The procedure is that for you to even assume jurisdiction, there must be a law. For the law to even exist, for you to rely on that law, the law must be an existing law. And Nnamdi Kanu now on his own filed a motion on this particular issue, telling my lord that the law upon which I'm being tried does not exist, in line with Section 36 sub 12 of the Constitution. But my lord on his own, just like what we said, my lord on his own said that section is talking about conviction. And Nnamdi Kanu said, no, you can't be talking about conviction without trial. The trial will lead to conviction. So for you to even talk about conviction, you must first of all address all those issues that will lead to conviction. So that is why we are here. It's not as if that you don't want to enter defense, but he's saying, tell me the law upon which I'm being charged and tried.
Why are we here at this stage, knowing that at the point he once pleaded not guilty, and then the witnesses from the prosecution were examined and cross-examined?
If you say that you are not taking plea, then how will you tell the judge to discharge and acquit you for no trial? Because you first of all plead guilty. Are you saying you first of all plead guilty for court to have jurisdiction for you to even make an application? If you do not plead guilty, there is nothing before the court. So that was the issue. And he's saying that if the law, the charges upon which I pleaded guilty, does not exist. We are talking about law.
Yeah, what about the trial? There was a trial.
The defense opening their case.
The prosecution.
You can raise it.
That trial.
The law said that you can raise all this issue at any stage.
Okay.
before judgment. You can raise it at any stage, either before prosecution open his case, upon prosecution closing his case, or at any stage. So that's the stage Mazi Nnamdi Kanu is. So on our own, so we believe that the court will first of all hear this particular